yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Before we get started, I want to just run over a few of the procedural rules that we utilize here. Make sure, I know everybody knows what those rules are, but I always feel better if I've actually said it. First of all, each side gets 15 minutes to make your argument. If you are the appellant and you wish to reserve any rebuttal time, please request that from the court after you've introduced yourself and before you begin your oral argument. You may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. In order to keep up with your time, we have a lighting system on the podium. I think it's rather straightforward. Once you begin your argument, the light turns green. So long as the light is green, you've got plenty of time. Once you begin to run out of time, the light will turn yellow, just to give you the heads up that you're running out. And finally, when the light turns red, you are out of time. We ask that you please respect those time constraints. One very important thing, I don't think this applies to the next argument, but to this argument, these arguments are being live streamed. Think carefully about what you say, because once you've said it, it's out there for everybody to see, hear, and repeat. So it goes out automatically. So just be aware that we're live streaming the arguments. Your panel this morning consists of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis. I'm Steve Stafford from Dyersburg. Ms. Angie, anything we need to take up before you call the first case?
No, Your Honor.
You may call the case, please.
Catherine Pallekonda versus Vinay Pallekonda.
Good morning, Your Honors.
Good morning.
My name is Andrea Sipes, and I represent Dr. Pallekonda in this matter. I'd like to reserve 2 minutes for rebuttal.
All right, 2?
Yes, sir.
Okay, thank you.
Your Honor, first, as to our third issue regarding equitable division of the estate, I have come across a case that I believe nullifies our argument on that issue, and so therefore I waive that third issue to begin my oral argument.
All right, thank you very much for letting us know that.
Yes, Your Honor. Our main argument involves the willful and voluntary unemployment finding against Dr. Pallekonda, which caused his support to be set at such a high rate. He was imputed at $36,000 a month when he actually only makes, before taxes, $26,000 a month. Now, Dr. Pallekonda is a skilled specialist. He was the chief medical officer at Jackson General. He left, and the court made a specific finding that he did not leave that job voluntarily. After he lost that job, Dr. Pallekonda engaged in a campaign to find other employment. He worked with, I believe, 3 separate headhunters. He did multiple interviews in multiple states. He could not find employment. He eventually found employment in Pensacola, Florida, where he had to take a significant pay cut. At Jackson General, he was making $625,000 a year, which included his clinical hours that he was allowed to work while at Jackson General. His new income in Pensacola is $320,000 base salary, and he is not allowed to work any clinical hours.
Let me ask you about that. I thought the testimony from the person from the Florida facility was that there was no restriction on that they didn't necessarily expect that he wouldn't be working, but that you were arguing and he was arguing that he was restricted from doing that. But according to the testimony from that person, there was no restriction in his contract that would not allow him to do that if he chose to do it.
Yes, sir. That testimony was in there, but I believe there was additional testimony about how none of the doctors at his hospital were participating in clinical hours, and that she could not say what the result would be of him attempting to do so because no one had done it and he had not asked about it.
That doesn't mean he can't do it.
That's correct, Your Honor. It does not mean he can't do it, but Dr. Pallekonda's testimony was that he could not do it because it was not permitted. That's why no other doctor at the hospital does it.
But that's not correct.
That was Dr. Pallekonda's testimony, Your Honor, that none of the other doctors participate in it, so that if he attempted to participate in it, he would lose the employment because he's not allowed to moonlight with this job as chief medical officer.
How does that reconcile with the testimony?
Well, I think it reconciles, Your Honor, because she says that she cannot tell you what the effect of him taking these hours would be. She says he has not asked about clinical hours. No other doctor at the hospital participates in clinical hours. She says that. And I believe she says that she cannot say what the effects to Dr. Pallekonda's status at the hospital would be if he were to take these clinical hours.
Isn't this position a similar position to the position he had here in Jackson, where, I think it was, where he was able to work and earn an additional $200,000 a year in clinical?
Yes, sir, but Dr. Pallekonda's problem is if he takes on the clinical work, the moonlighting work, then he will lose his base employment at the hospital in Pensacola.
How do we know that?
And by Dr.
How do we know
Pallekonda's
that?
testimony.
How do we know that?
By Dr. Pallekonda's testimony, Your Honor, and by the fact that when the lady from the hospital was questioned in her deposition, she could not give a definitive answer either way. She said basically, I don't know because it's not done. And if none of the other doctors at the hospital are participating in this moonlighting when, as I understand in the medical field, this is quite common, I find that very telling and very supportive of Dr. Pallekonda's position, which is that he would be terminated if he engaged in this moonlighting.
Did anybody tell him he'd be terminated if he participated in it, or is he just assuming that?
Your Honor, in his testimony, it is not clear where he draws that conclusion from. He seems to indicate that he was told that. He seems to indicate it's part of his employment contract, which it is not. And so he is unclear in his testimony as to why he believes that he would be terminated, but he is adamant that he would be terminated if he were to moonlight on these clinical hours.
But there's no evidentiary support for that.
Well, in addition, Your Honor, where he's located, his moonlighting would not be, so at Jackson Madison County General, he was allowed to moonlight within Jackson General. He would not be able to do that within the hospital where he works now, according to his testimony. So he would have to go and travel quite a bit to find clinics and things that were not tied to that hospital. And so it would be very difficult for him to work the clinical hours because he doesn't have the same access to them as he did at Jackson General.
Well, was there any testimony of anyone who told him that he couldn't do it at the hospital in Florida?
I believe he testified that he was told by the lady that was deposed that he could not work clinical hours. However, I cannot submit to the court that that was what she said. She said that it was an unknown possibility because no one did it and Dr. Pallekonda had not asked about it.
So this whole argument is based on his testimony with no supporting testimony from anybody else as to the fact that he couldn't do this. Is that what you're saying?
Your Honor, I think it's his testimony coupled with the fact that in the deposition, she cannot refute what Dr. Pallekonda is saying. Apparently, according to her, the hospital doesn't know what it would do because no doctor does it. And I think the fact that no doctor at their hospital participates in these clinicals is very telling of the hospital's maybe unspoken policy regarding working clinical hours. But Dr. Pallekonda is not deliberately not working these hours. He can't work them or he will lose his employment, his base employment, which is what he's living off of or trying to live off of right now. But this finding of voluntary and willful unemployment is simply incorrect, Your Honor.
What did the court find about this quagmire here?
Your Honor, the court went through and used an analysis, I believe a 10-year analysis of Dr. Pallekonda's income and what he had made over those 10 years.
So the court did what as far as this testimony?
As far as Dr. Pallekonda's testimony, Your Honor?
The testimony about his inability to moonlight.
The court was not swayed by Dr. Pallekonda's testimony on that matter.
Did the court make a specific credibility finding?
I do not recall that the court made a specific credibility finding. I do recall that the court said that it appeared to the court that Dr. Pallekonda could work these clinical hours if he chose to do so. I do believe that was the court's finding.
Perhaps not an explicit, but an implicit finding that he didn't believe your client.
Implicit, perhaps, Your Honor, but not stated. And I think it's relevant to note that the court did find, and this was based on Dr. Pallekonda's testimony, that he did not leave this employment voluntarily. And I think we have to look at that when determining voluntary and willful underemployment, because he's not doing it to defeat child support or to defeat alimony. He could not find another job where he could make a comparable wage to what he made previous. And while I understand that the clinical hours are in question, there is no proof as to how much money he could make in Florida off of those clinical hours.
Well, who has that burden?
Well, if they are asserting that he is willfully and voluntarily underemployed, Your Honor, the appellee has the burden. The person seeking the finding of underemployment has the burden to prove it. I would submit...
Let's explore that just a moment.
Yes, sir.
The proof is he had a job where he made more money, correct?
Yes, sir.
And that he did not voluntarily leave that job, but he did leave that job.
Yes, sir.
And he took this job making less money.
Yes, sir.
Did he testify about other efforts to obtain similar employment and those type issues?
He did, Your Honor. He worked with 3 separate headhunters and attended multiple interviews in multiple states, I believe in Michigan, California, I believe here in Nashville, I believe, and finally in Pensacola. And his testimony was basically that no one would hire him because he resigned from Jackson General to avoid termination. And that was in the testimony as well. But he made every reasonable effort to find comparable employment. He's just been unable to find it. And as my grandmother says, you can't get blood out of a turnip. So he is incredibly behind in his support payments because he does not have the money to pay them. His alimony and child support together are so high that he only has a couple of $1,000s left after paying his taxes for him to live on. And that is just, to me, absurd, because doesn't he not deserve to also have the marital standard of living? In addition to that, we're arguing that the court should have awarded rehabilitative alimony rather than transitional and in futuro. Our state favors rehabilitative. Transitional alimony, as I understand, is supposed to be for the spouse to transition into being able to support themselves in their new single lifestyle. However, in this case, the wife could have been rehabilitated. She is a registered nurse. She was a registered nurse when she met Dr. Pallekonda. She could get her licensure in Tennessee. She has chosen not to. She could additionally look for other employment. She's highly educated. She's got specialized skills, but she does not pursue that. And her reasoning for that is that her youngest child, EP, has some significant medical issues. However, I would submit, Your Honors, that if you read the transcript, you will see that he is high-functioning autistic, very intelligent, doing well in school. His only issue is he struggles with social interactions. I would not submit that that is of a high enough standard to warrant her staying at home and not working. I would also submit to the court that I would believe any spouse would have a duty to try to rehabilitate themselves to the best of their ability, because is it permissible for her to do nothing and continue to draw this money where she can maintain her marital standard of living, but Dr. Pallekonda cannot. As a registered nurse.
Did the trial court make specific findings about that, about the ability to rehabilitate?
Your Honor, I do not recall. Chancellor Maroney made findings that she was a nurse, that she had stopped working in 2006, that with the child and caring for the other child, GP, that it was not feasible for her to work outside the home. We are arguing that that factual finding is incorrect, because if you read the transcripts, it's very clear that this child is high functioning, attends school just like every other child does, and there's no reason for her to stay at home and care for this child. I would like to point out.
Well, didn't the court actually make a finding that, that she was capable of some work, but that he said further, wife is capable of some work even without undergoing any sort of rehabilitation process in terms of bringing up her skills. So he made a finding that rehabilitation just wasn't necessary in this case.
Your Honor, my time has stopped. Do I have permission to answer? Your Honor, I believe that the court did not make a proper finding on the rehabilitation. I think the facts support that she could be rehabilitated at least to some extent, and it would be our argument that there should be a requirement that she have to at least attempt rehabilitation before transitional and in futuro alimony becomes the final ruling in this case. Thank you, Your Honor.
Let me ask you, you said the base salary was $320,000. Is he also entitled to some bonus?
He is entitled to a bonus, Your Honor. I do not know, and I do not believe at the time of trial he knew how much that bonus would be. But yes, he is subject to a bonus, as I understand, at the end of the year.
At the end of the year. And that bonus, is it 20 or 25% of his salary? Do you know?
I do not know that, Your Honor.
And do you know whether if you add the bonus to his base, would that give him sufficient income to pay the alimony and child support?
I do not believe that the bonus would be sufficient, Your Honor, and I do not believe that the record supports that the bonus would be sufficient if it was discussed. And I apologize for not asking for permission to answer that question, Your Honors.
No, you may always answer a judge's question, trust me.
Thank you, Your
Thank
Honors.
you. All right.
Good morning, Your Honors. Laura Butler from Memphis, Tennessee. I represent Mrs. Pallekonda, and I'm the appellee. I would like to respond to Ms. Sykes' statement that he went on a campaign to find a new job. She cites in her brief to 2 pages, 162 to 163, where he discusses that. But there's very little information about his job search. There is, or his justification for his income essentially being cut in half. In 2020, he made $704,000. At the time of trial, he was at $320,000. And while it is our burden of proof to show that he is underemployed, it is certainly he had some explaining to do as to why his income had been reduced. But there is, if you read page 162 to 163, he never says that he couldn't, that they rejected him. He said, oh, I had applications in Detroit. Yes, I looked in Nashville. There was a headhunter said there was something in Texas. He never said he didn't get it. He just said that he ended up going to Pensacola, where he was hired by Dr. Monique Butler. And I think, Judge Golden, you had asked about Dr. Butler's testimony, and in fact, on page 8 of her evidentiary deposition, she does say, it is uncommon for any of our physicians or any of our executives to do so. They do not have time to be able to work outside according to job responsibilities in the amount of time, but there's nothing that says that he cannot work outside of the hospital. So she specifically did state that there was nothing preventing that. He cannot work within the hospital because it's a conflict of interest, but he can moonlight, and that is what he was doing when he was in Jackson. He was traveling to Michigan to moonlight and supplemented his income significantly, even while he was the chief medical officer here. So what So there's very little in the record by him as to why his income was reduced. But what is in the record is his statement in volume 3, page 168, line 13, which says, "I do not want to work like I was working before." So he said that. Importantly, Exhibit 7, which is in volume 5, his CV talks about how he's an accomplished medical officer, and he was boarded in internal medicine, critical care medicine, and anesthesiology. He was triple boarded. Exhibit 7 just goes through how successful he has been as a physician. He's quite talented, very smart. He just, in our opinion, does not want to work like he did before. He wants to ease out. And I understand that, but unfortunately, he has financial responsibilities. What is also in the record is Exhibit 8, which is his Social Security statement that I have cited to numerous times in my brief. But if you look at his income, beginning in 2011, the parties married in 2003, and my client did work as a nurse for a few years after that. She stopped in 2007, just before they had their first child. And Dr. Pallekonda, unfortunately, had to enter into a rehabilitation facility due to some sex addiction, which there's no point in getting into that. But my point being, my client stayed. She stuck with him through these lean years where he made very little and actually helped support him. And in 2011, after he was healed or healing from his trauma, his income trajectory just went through the roof. I mean, we're starting at 112, then went to 220, then 328, 345. 2015, he was making $610,000. 2018, 609, 600, and then finally in 2020, during the pandemic, he made $704,000, and a lot of that was due to moonlighting.
And that was moonlighting in another state, is that right?
So it depends on the year. In 2020, when they were in Jackson, through 2021, he was working at Jackson, what I call Jackson General, the hospital, and he was moonlighting back in Michigan, where he had previously worked. He would go on the weekends, and so that, for that year, that was a lot of moonlighting income. As far as his job search...
Did he indicate why he couldn't do that? Something like that?
He did not. In fact...
I'm not sure I recalled that he did that he actually went to another state to moonlight.
He did. He traveled to Michigan to work at his previous... And he has a good relationship with that employer, as a matter of fact, and testified that, and I have it in my notes exactly where it is in the record, it is volume 3, page 165. Dr. Pallekonda testified on cross-examination, when I cross-examined him, that Detroit would take him back in a heartbeat. Now, he said, when I questioned him about that, he said, well, that's if they have an opening. And he said they just didn't have an opening at that point. But he said they would take him back in a heartbeat if he had an opening. So
let me ask you, his moonlighting, was that emergency room coverage on the weekend? Is that what he was doing?
I believe so, Your Honor.
Okay.
Yes, it's all detailed in his CV, which is Exhibit 7, okay. All of the different things that he did. As far as the way that the trial court handled Dr. Pallekonda's income capacity, I think he did a very fair job of analyzing it. The case that we relied upon in the situation was the Andrews versus Andrews case, which I'm sure this court is aware of, where the physician also claimed that his income was going to be reduced because he couldn't moonlight anymore. And that court took a 6-year average, the previous 6 years. If you follow the reasoning in Andrews and take a 6-year average of Dr. Pallekonda's income from the time of the divorce in the previous 6 years, it's approximately $51,000. If you look at his previous 6 years, right before the divorce, it would be about $50,000 to $51,000. This Chancellor Maroney, I think, cut him some slack and said his earning capacity is $36,000. And I believe that you asked, or maybe you, Judge Armstrong, asked about the $320,000 base. It is in the record. I don't have the site right in front of me, but he has the ability, on top of the $320,000, to have 25% bonus. And there was nothing in the record indicating that he couldn't make that bonus. It was new at the time of the trial, so we didn't have any information. But 25% of $320,000 is $80,000. So if you add that, that's a $400,000 salary.
And then monthly, that would be what?
At monthly, that is going to be, it's in my brief.
Okay.
I can't remember. I think it's about $32,000.
A little bit less than the 36.
It's a little bit less than 36. I believe it was $32,000 just on what he's earning. That does not include the ability of him to go to other facilities outside of the system that he is working in to moonlight.
And what's your position about, let's assume it's at 32,000, is that sufficient to pay the 9 and the 3,200?
Yes, Your Honor, it is. I have not completed a worksheet on that. I don't know if that is going to reach the cap or not, like the $36,000 did, but it's our position that even if the court did find the earning capacity to be lower than 36, that doesn't necessarily mean that it's going to change anything. It's very likely, although I haven't done the worksheet, that it still could be at the cap, because the court did not make any finding about what my client could make. So she's got 0 in her column. He's going to have some high number, whether it's $36,000 or $32,000 or $26,000. It's going to be a high number in the worksheet, and also the alimony is $9,000 for 72 months, and then $7,000. He still has funds to live. He lives at Pensacola Beach, Florida. And she lives in the Nashville-Franklin area with the children. So he sees the children once a month and on holidays. So she's the primary caregiver. They are with her a majority of the time. So he has the ability to go out and work. He doesn't have to keep the kids at night with him or help with homework. I mean, he's able to do that. As far as alimony, I'm not sure I understand the argument. I think that they are just saying that it should be rehabilitative alimony as opposed to transitional and in futuro, but doesn't challenge necessarily the amount or the duration. But as far as rehabilitation goes, the definition in the statute is that, and it's TCA 365121D2 and E, it means with reasonable efforts, the disadvantaged spouse will be able to achieve an earning capacity that will permit the economically disadvantaged spouse's standard of living after the divorce to be comparable to the standard of living enjoyed during the marriage, or to the post-divorce standard of living expected to be available to the other spouse. And I think that is important to know that during the trial there was a lot of testimony and a lot of evidence put forth about spending, discretionary spending that Dr. Pallekonda was engaging in after he left and went on to Pensacola and started his new job. There were thousands of dollars he couldn't account for, and in fact, Chancellor Maroney made a finding that $19,000 was even dissipated. And I have cited in my brief many large withdrawals that he was spending. He was buying expensive clothing and traveling, and at one point he wouldn't even he got an Airbnb even though he had an apartment in Pensacola because his girlfriend was staying at his apartment. I mean, he has the capability of having the same standard of living, and Mrs. Pallekonda, according to the law, should have a comparable standard of living. And there is no way, after being out of the workforce since 2007, by the choice of both parties, that she would ever achieve a standard of living comparable to Dr. Pallekonda. She just can't do it. And so I do believe that Chancellor Maroney was correct in awarding the transitional and then the in futuro on top of that. Opposing counsel made a comment that Ms. Pallekonda could get back in and have a high earning capacity, but as I've cited in my brief, she stopped working in 2007. She was a nurse, a registered nurse. She is 54 years old. They have a special needs child. He is high functioning, but she still has to spend a lot of time and effort. They have some ways to go, and I've cited that in my brief. She has to take him to school. If it's a 25-minute drive, she has to pick him up from school. She doesn't have any family in the area. So to suggest that she could just launch back in and have a lucrative nursing career is probably not likely at this point. Dr. Pallekonda also testified that he is in a relationship with somebody. He denied having a sexual relationship with this person, and it's not important other than he stated in volume 4, page 325 through 326 and 370, that this person that he was with now is very wealthy. She had an inheritance, and he allegedly borrowed a ton of money from her, and that's why he was giving money back to her. And so that's probably why he doesn't need anything more than a $320,000 job at this point. But he clearly has the capability, if you look at the history of his work history. He's very accomplished. And with I had saved the rest of my time for the property division argument, which she has withdrawn. So, any questions?
See none. Thank you.
Thank you.
Your Honors, I would like to respond to the Andrews case. I would like to say that first, while that case appears on its face to be analogous to this case, it's actually distinguishable. The doctor in that case testified that he just didn't want to work clinical hours. In Dr. Pallekonda's case, it's that he cannot work clinical hours. The husband in the Andrews case...
How do you reconcile that with that testimony that was just stated to us that said that he wanted to cut back, he didn't want to work like he did in the past?
He did say that, Your Honor, but that was not the sole reason or the sole motivating factor for the clinicals not being worked. It was a matter of geography and being able to go places and do those clinical hours that was reasonable given his workload at the hospital. The doctor in Andrews also...
Were you aware that he was working out of state when he was working here, that he was actually doing those clinical hours in Michigan?
Yes, sir, he was, but Michigan cut those hours because, as I understood from the testimony, they no longer needed him in that position. And I think that testimony went along with the testimony that Michigan would take him back in a heartbeat if they had an opening. And there was no proof that there was an opening. And in the Andrews case, the husband in that case gave financial statements where he inflated his income up to $1 million. I would also point out that we are speaking of this and need to take into account that he has to pay the IRS as well. And I would hate to see his tax bill on $320,000 or $400,000. Your Honor, it's our position that the wife should have some responsibility to try to rehabilitate herself, and that Dr. Pallekonda should be able to enjoy the same standard of living as she does.
Is there any proof in the record about what his net would be monthly based on that $400,000 salary, which includes the base and the bonus?
My time has,
Net monthly be?
my time has expired. May I answer? I do not believe there's anything in the record about that, Your Honor.
Okay, all right.
Thank you.
Thank you.
Thank you, counsel. We appreciate your argument. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time.
Thank you.
Thank you.
Thank you.
You may be excused.